Mr. Rowe, state your name for the record, please.
Miles Rowe.
All right, go ahead.
Your Honor, today is the date and time set for sentencing. I did review the probation recommendation with Mr. Rowe. We do ask that you adopt the bulk of the recommendation, with the exception of the 5 days in jail. On behalf of Mr. Rowe, we are asking that the court either strike that recommendation or hold the 5 days in abeyance. Obviously, while Mr. Rowe is on probation, he will have the whole 93 days kind of hanging over his head if he were to violate his probation. He does understand that and is ready to complete this term. Regarding the 5 days, he did let me know a couple reasons why this would have a negative impact on his life circumstances right now. He is working a temporary job, or he's working a job where he's a temp. He's in his probationary period, basically. He's just a few weeks away from those 90 days where then he will be made a full-time employee. He doesn't have any time off or any sick or vacation days that he can take for the next couple of days. So he's very worried that he will lose his job if he were to be remanded. Additionally, he does have 2 children, a 16-year-old and a 4-year-old. He told me his 4-year-old will be with him full-time this weekend. The child's mother is going on vacation, so he is the primary caregiver for the next couple of days. So obviously does not want to be away from his child. He is also helps care for his family. His father just had back surgery. They own a farm up north, so he assists with that farm.
Down here too.
Two farms, okay.
Yeah.
So he assists with that farm, especially given his father's medical conditions, helping with run the farm and helping his father through this medical situation. His girlfriend is here as a support system. His family is very supportive of his sobriety. He even mentioned that his sister's going to school for drug counseling, and she's supportive of his sobriety. We've had multiple conversations over the last couple of weeks. He, I think, is very ready to be sober. He's talked to me multiple times about how this has basically changed his life. He appreciates the tether keeping him accountable. He says he's willing to wear it for as long as the court wants because he appreciates the changes that being sober has made in his life. He did do as an assessment. The assessment says he's low risk for consumption because he also demonstrated to the assessor that he's ready to change his life conditions and is really on a good path. We also did talk lastly about the fines and costs. He believes he can post at least $400 today.
So anything you want to say before I impose sentence?
I mean, I could pay the whole thing in full today if I don't have to do the 5 days. If I have to do the 5 days.
Does this look like a negotiation to you?
No.
Go ahead. You can tell me anything else you want.
I mean, I'm just afraid of losing my job, so I wouldn't be able to pay.
Well, then you should have thought about that before you tampered with our device.
I didn't do a tamper with it, but I don't, as I did, so it is what it is. I don't know what else to say. I was just working.
Go ahead, sir. Anything else you want to tell me?
Other than the fact that being sober is about the best thing that I've had happen to me in about 10 years. So I appreciate it and I take full responsibility for my action and hate that it happened. And I want to move forward and just move on with my life and take care of my family and not lose my house and keep everything going.
The court does acknowledge this is not a serious misdemeanor as defined by statute. However, it does believe there are reasonable grounds to depart from the presumption of a non-probationary sentence. The alcohol screening and assessment identifies the benefit of outpatient treatment, driver's intervention class, and abstinence from all intoxicants. Therefore, the court will follow the recommendation of probation for a probationary sentence with the stated rehabilitative goals to promote change, prevent recidivism, monitor compliance, and recommended treatment. Therefore, the sentence of the court, you're placed on probation for a 12-month period in time. You're to pay $855 fines and court costs, $100 prosecution recovery cost, $100 police agency recovery costs, and $360 probation oversight fees. You pay $400 today. How are you going to pay the balance?
I can do a payment plan for whatever.
A payment plan is directed by probation. There's to be no use of alcohol, recreational marijuana, or illegal substances. You'll be subject to random testing as requested by probation. You are to complete outpatient treatment, including all recommended aftercare with status reports to probation. You are to provide proof of victims' impact panel attendance to probation. The scram tether will continue until proof of treatment is received by probation. So with reference to the jail time, and why I'm clearly indicating that this is not it's not a negotiation of fines and costs. You were 0.224 and there was a crash of the vehicle that very well could have been a crash that took somebody out.
I know.
So, well, you can know it, but I don't know that you appreciate it. You're not in a position to negotiate. Then when I put you on the scram tether, I all of a sudden get a notification of a tamper with it. And through the tamper, it still suggests that there was alcohol. And you're telling me you didn't do it, but
I was running a chainsaw with the fumed ethanol gas in it. I mean, that's just the only thing I can say. That's all I can say.
There's not a chainsaw in the world that's going to set that thing off.
I mean,
93 days in jail, credit 1 day served. Defendant will serve an additional 5 days in jail due to the bond violation, and then the balance will be suspended. Defendant's remand.
Defender J. Bellinger on behalf of Mr. Ginyard.
for the record, Your Honor, my name is Terrence Ginyard.
And Your Honor,
He's waiving.
he is waiving. I do have an offer to place on the record as it stands. That offer is that he waived for the purposes of pleading to 1 count of the firearms possession by a prohibited person. Count 2 and count 3 would be dismissed. It would also be a plea to count 4, the misdemeanor receiving and concealing 200 or more. That would come with a forfeiture of the weapon, restitution, if any, standard conditions upon that waiver. That's the people's understanding.
All right. Mr. Ginyard, you're waiving your right to a preliminary examination, sir?
Yes, sir, Your Honor.
All right. You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir, Your Honor.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, I do, Your Honor.
All right. People also waive the right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on counts 1 through 3 with 4 following.
Your Honor, we would acknowledge receipt of information, waive formal reading, stand mute at this time.
Defendant having waived formal reading, standing mute to all counts, court will enter a not guilty plea. Pretrial will be set for
January 27th at 1:30 before Judge Simpson.
January 27, 2025, 1:30 before Judge Simpson.
Your Honor,
Yes,
if we may address bond at this time.
briefly.
Your Honor, my clients, I think the court has the information from last time with regard to the blood results that he was able to take. At this time, I am still asking for his release. He's willing to do tether at whatever conditions that the court deems necessary he received a 7-day notice to quit, eviction notice that starts today. He has also got a kid who is autistic, whose birthday is today. He lost his job, unfortunately, as a result of this case, understandably so. He's going to need to move out of that location, as the court knows, for purposes of securing new housing for his family, his children especially. I would just ask for his plea for his release at this time on PR.
Any response from the people?
No, Your Honor.
Well, why are you drinking?
Sir, I wasn't,
Go ahead.
So I got the blood test on the 2nd to show that I wasn't drinking. I wasn't drinking, Your Honor, on the 22nd. I didn't have any alcohol. That's why I went out my way to pay for a blood test. And the blood test, the levels was 1.0 and it said 1.4 is 0 to low alcohol.
Yeah, but
Yes, sir.
I remember going through all of that last time, and I'm telling you that test doesn't tell me much.
We understand that, Your Honor.
Because I got repeated tests where on the 22nd and the 27th, you're testing positive, you're drinking.
The one time I did say that I was drinking in November, Your Honor, I did admit to that. I definitely did. And you said we'll put it for
Put it over.
we'll adjourn it or whatever. And then we just got to this adjournment with what I proved that I wasn't drinking. And you
No, you didn't.
sir.
Oh, hold on.
Okay.
You didn't. That's not what that test shows me.
I have, so CMH has given me what I wanted to tell you, a shot.
The Vivitrol.
Yes, and that's like an alcohol blocker. And they said if I drink on that, bad things can happen to me.
Where is that?
That's with CMH, sir.
Your Honor, I don't have receipt.
I don't have that before me. You're telling me that
That's what I'm going to be put on. I'm already taking.
so you're not put on it right now.
No, sir.
Your Honor, I would ask for consideration for random drops at this point, if the court would be willing to consider that. I think that would, I think testing in front of someone at this point may be helpful in terms of monitoring the situation versus the scram tether or sober link. I would ask for consideration for that. I do know that my client has a desperate need to leave the jail.
I understand that, but I also understand what he's done to get himself there, because he wasn't there to start with. And now you're asking me to change it, and I haven't been shown anything really that's convinced this court that those episodes didn't occur. And he's not on a medication that's going to stop him from drinking.
For your mama. Hey, dude, I'm on.
Seriously. So this is, I mean, nothing's changed from the last time that I denied it. And so he'll be up for Judge Cedric. Maybe she'll feel differently than that, but
I'll do anything to any type of drops, though, Your Honor. They do want to put me on the thing today as far as the Vivitrol. They told me tonight I can get a shot, but it's also if I'm going to be here.
You're telling me that, but I don't have anything that indicates that. I have nothing in writing saying that's what's going to happen.
I just was trying to move, man. I know I have to move, but I have a 7-day eviction. Since I've been in here, I don't really know what to do. I don't. I have an autistic son. I have a lot at home.
Ginyard, I understand and I can appreciate the circumstances.
No scram tether or anything I can do, sir, for you? Anything, just for a week, just to show till I come back to court?
I'm not changing my position on it. I've said what I've said. You can take it before Judge Cedric. She may feel differently.
All right.
Bond is denied. Thank you.
Thank you, Your Honor.
Motion for bond reduction. Court calls the case, people.